Be ready. 5 seconds. Start. Selection is to be made giving strict adherence to the statutory provisions, and if such power that is inherent jurisdiction is claimed, it has to be explicit and cannot be read by necessary implication, for the obvious reason that such deviation from the rules is likely to cause irreparable and irreversible harm. Stop. Similarly, in a case, this court held that selection criteria has to be adopted and declared at the time of commencement of the recruitment process. Stop. The rules of the game cannot be changed after the game is over. Stop. The competent authority, if the statutory rules do not restrain, is fully competent to prescribe the minimum qualifying marks for written examination as well as for interview. Stop. But such prescription must be done at the time of initiation of selection process. Stop. Change of criteria of selection in the midst of selection process is not permissible. Para. Thus, law on the issue can be summarized to the effect that in case the statutory rules prescribe a particular mode of selection, it has to be given strict adherence accordingly. Stop. In case no procedure is prescribed by the rules and there is no other impediment in law, the competent authority, while laying down the norms for selection, may prescribe for the tests and further specify the minimum benchmarks for written test as well as for viva voce. Stop. In the instant case, the rules do not provide for any particular procedure oblique criteria for holding the tests. Rather, it enables the High Court to prescribe the criteria. Stop. This court in All India Judges Association and others versus Union of India and others, AIR 2002, Supreme Court 1752, accepted Justice Shetty Commission's report in this regard, which had prescribed for not having minimum marks for interview. Stop. The court further explained that to give effect to the said judgment, the existing statutory rules may be amended. Para. The view taken herein above, it is conformity with the law laid down by this court in Nand Kishore versus State of Punjab, wherein it has been observed as under. Stop. Their lordships' decisions declare the existing law but do not enact any fresh law, is not in keeping with the plenary function of the Supreme Court under Article 141 of the Constitution, for the court is not merely the interpreter of the law as existing but much beyond that. Stop. The court, as a wing of the state, is by itself a source of law. Stop. These cases are squarely covered by the judgment of this court in Hemani Malhotra versus High Court of Delhi, AIR 2008, Supreme Court 2103, wherein it has been held that it was not permissible for the High Court to change the criteria of selection in the midst of selection process. Stop. This court in All India Judges case within bracket Supra had accepted Justice Shetty Commission's report in this respect, that is, that there should be no requirement of securing the minimum marks in interview. Thus, this ought to have been given effect to. Stop. The court had issued directions to offer the appointment to candidates who had secured the requisite marks in aggregate in the written examination as well as in interview, ignoring the requirement of securing minimum marks in interview. Stop.